So welcome back everyone to our tax dispute series. This segment is the third segment in our life cycle of an early stage tax dispute. This session is going to cover informal document requests from HMRC and Schedule 36 information requests. If you want more information on early stage inquiries, including what to look out for if HMRC open inquiry into a tax return, how to correspond with HMRC in relation to early stage disputes and discovery assessments, do take a look at the other recorded sessions from the series by me and my other tax colleagues. So if we take a look back to our example, just by way of reminder, it's set out on the slide. Where we are is we're between the third and the fourth bullets on the timeline. So this session is going to cover the informal document request, that's the third bullet, and the issue of Schedule 36 information notices, and that's the fourth bullet. Now, just to note that we focused on a company in this example, but a lot of the points that we've made in this series will be applicable to partnerships or individual taxpayers too. So we'll take a look at informal document requests first. Now, HMRC guidance says that HMRC should only request documents and information which are reasonably required for the purposes of checking the accuracy of the return, and the HMRC would be able to request later in an information notice under Schedule 36, and we'll come on to that later. It's often unclear from their requests what HMRC are actually getting at. So as the taxpayer, try to answer HMRC's questions, but try not to offer up too much information. So try not to offer up loads of additional information that HMRC haven't asked for. Occasionally, HMRC aren't forthcoming with their technical arguments. So what they might be trying to do is draw out more information from you without having to give away what they're actually driving at. So the aim is to try and be as helpful as possible and provide enough information to HMRC to answer their questions and to be as helpful as you can be from a HMRC relationship perspective. But you're also hoping that further questions raised by HMRC are going to be more specific, and you can then answer those with the aim of getting HMRC to discontinue and ultimately close the tax inquiry. On the flip side, HMRC are going to be trying to glean as much information as possible from the taxpayer, because if it suspects that something isn't right, for example, the taxpayer hasn't paid enough tax, it may not be for the reasons that HMRC first suspected. So the more information they can get from the taxpayer, the more HMRC may have to put forward their arguments as to why the taxpayer hasn't paid the correct amount of tax. In considering what to request from the taxpayer, HMRC should have regard to the burden on the taxpayer to provide the information and how important the information is in deciding the correct tax position. Obviously, HMRC will consider that the latter point is more important than the former, and it's probably only where there's a real burden to producing information that the taxpayer will be able to argue the burden is too great. For example, if the taxpayer has to trawl back through large sets of data or undertake an electronic search of company databases to access documents from certain individuals, that's where that's likely to be in play, where it's going to be too burdensome for the taxpayer to do so. If HMRC, on the other hand, has requested a specific document or a set of documents and they're described accurately, it's likely that HMRC would be able to say that the taxpayer should have kept sufficient records for the purposes of producing its tax return, and accordingly, that the taxpayer should relatively easily be able to provide the information requested. It's also worth noting HMRC could skip this stage altogether, as they're not obliged to make informal requests, and they could progress straight to using their legal powers under Schedule 36. And that's where they have good reason to believe it will be more efficient or more effective to do so. The examples given in the HMRC guidance where informal requests may not be made is where there's a history of non-compliance by the taxpayer or where tax evasion is a feature of the case. So from the taxpayer perspective, in order to not create a history of non-compliance for the particular taxpayer in question for any future inquiries, it's therefore sensible to comply to the extent you're able to with any informal document requests. Again, this goes to the reputation of the taxpayer with HMRC. As a taxpayer, there's a number of practical points that you need to consider when you're answering informal document requests from HMRC. The first is disclosure and legal professional privilege, that's LPP on the slide. It's important for the taxpayer to consider whether it's waiving any privilege in disclosing information to HMRC. Legal advice privilege may apply where confidential communications are made between a lawyer and that lawyer's client for the dominant purpose of giving or obtaining legal advice. So you may have privilege over the advice that HMRC are requesting. You should always check with your legal advisors if you're in any doubt as to whether information should or should not be disclosed or might be subject to privilege. There's a couple of important points to note in the context of privilege. Privilege belongs to the client only, and only the client can waive it. So if an advisor is disclosing privileged documents on your behalf, you need to make sure as a taxpayer that you've consented to that disclosure and understand the consequences of waiving privilege. Generally, if confidentiality in a privileged communication is lost, then privilege in the communication is also lost. And finally, waiver of privilege in one document could trigger a collateral waiver of privilege in associated documents. So always be mindful where one document has privilege and that's waived to disclose that document to HMRC, that could have a knock-on effect for other documents. Again, as I stressed before, it's really important if there's any doubt from the taxpayer's perspective as to whether a document is privileged, it's really best to seek legal advice before documents are disclosed to HMRC. Another point to check is confidentiality clauses. So taxpayers, you should check whether the documents you're intending to disclose impose a condition of confidentiality if you're a party to the document that you're disclosing. So in practice, this could be a confidentiality obligation in a share purchase agreement or an investment agreement where the parties to that document are not allowed to disclose confidential information. Although sometimes you do get carve-outs to those provisions which allow you to disclose to a tax authority, or potentially if it's required by law, in which case you may only be able to disclose at the point when you've got to a formal inquiry or a Schedule 36 information request from HMRC. Another example is where you might be disclosing accountants' reports and you need permission from them to disclose that document. Importantly, you should check the terms of the document before it's handed over to HMRC. Another point to be aware of, but this isn't the talk to go into detail on this point, is data protection and the General Data Protection Regulation. That applies to the processing of personal data by automated means. So as a taxpayer, you just need to be mindful of your obligations under GDPR if you're disclosing personal data to HMRC. And the final point that I've just noted here is that you should consider other parties. So are there other parties involved? For example, on our current inquiry, there's an inquiry into the company. Now, the company will have shareholders, so it might be worth checking with those shareholders whether HMRC has asked questions of those shareholders or open inquiries into their tax returns. It would be a good idea to make sure that all parties are aligned in terms of what information is being provided to HMRC and that everyone is adopting a consistent position as regards the tax that HMRC are inquiring into. So overall, that really goes to the key message, which is when you're providing the information to HMRC, you want there to be a consistent message and you don't want conflicting messaging to be conveyed to HMRC. You should always be considering the possible next steps of inquiry and the consequences of disclosing a document against not disclosing a particular document or a particular set of information. It's worth noting, however, if you ultimately decide not to disclose documents to HMRC, then the next step HMRC is likely to take is to issue a formal request for the information using its information powers. And that's what we'll come on to now. So when HMRC want to issue a formal notice, that's also known as a Schedule 36 information notice because it refers to Schedule 36 of the Finance Act 2008. Those provisions give HMRC powers to check a person's tax position. Broadly, those powers enable HMRC to obtain documents and information and to inspect business premises. So in our example, HMRC have issued the corporate taxpayer with a taxpayer notice under paragraph 1 of Schedule 36. That requires the company to provide information or produce documents that HMRC say are reasonably required for the purposes of checking the company's tax position. Now, tax position for these purposes is widely defined. That includes past, present, and future liabilities to tax, penalties, and tax claims, tax elections, applications, and notices. The powers apply to all the major taxes, and that includes corporation tax, which is the tax that's at stake in our particular example. In terms of the documents that are reasonably required by HMRC, case law says that information is only reasonably required if there is a sensible or reasonable possibility of HMRC being able to make an assessment of the unpaid tax. On the other hand, HMRC only need to show that the information is required for its investigation, i.e. to establish the facts, not that the investigation itself is reasonably required. So in this case, we've got a taxpayer notice, and that's been issued to check the company's tax position. There are other notices that can be issued, such as third-party notices, but we won't go into the detail of those for the purposes of keeping this a short briefing. The taxpayer notice should be expressed in clear terms, so both parties can establish whether it's been complied with. That won't be the case where the request is based on an assumption that's disputed by the taxpayer. The notice needs to specify the information and documents to be provided, the time period for producing the documents, and where the documents are to be produced. Now, copies can be provided unless HMRC require originals, and electronic records are included. So documents for this purpose includes anything in which information of any description can be recorded. Now, again, there's a number of practical points that should be considered if you're a taxpayer and you receive a Schedule 36 information notice. So the first is, has the information notice been validly served? Now, some of the points that were discussed in segment 2 here will be in point. So has the information notice been sent to the right company? Has it been made within the requisite time periods? And it's also worth noting that there is an example of a non-tribunal approved taxpayer notice in HMRC's guidance. So if you receive one of these, it might be worth checking the form of the notice that you receive against the form of the notice in HMRC's guidance. Other points to consider are the documents reasonable for HMRC to request? You should consider the parameters of the information request. If providing the documents is going to be overly burdensome on the taxpayer, considering whether it be possible to agree a process with HMRC to undertake the search for documents. So if there are electronic searches that need to be done, can these be done on particular servers within a particular time frame, or keywords to determine the search parameters that are going to be carried out, and therefore the documents that need to be disclosed. So HMRC may also, in that instance, if you're looking at electronic searches, they may also ask for a search to be undertaken for non-electronic documents. So it's worth bearing that in mind. Another point to consider is whether the documents are within the taxpayer's possession and control. Now, this is a question of fact, and it will turn on the individual circumstances, as possession or power is not defined. But very broadly, if a person owns a document, it's likely to be in their possession or power. So if you have access to a document, it's likely that you'll have to disclose it to HMRC. And again, as with the informal document request that we covered earlier in this session, consider the requirements to disclose information, and if you've got any legal professional privilege that might apply, and whether there would be any waiver as a result of disclosing. Hopefully that's been a helpful summary of Schedule 36 and informal document requests. And as I said, if there are other points that you're interested in early stage tax disputes, do refer to the other sessions in the series. Thanks very much for listening.